In California, the distance between a venting session and a felony strike is often determined by a single dangerous mistake, judging your case solely by the words spoken. It happens fast. You get into a heated argument, a neighbor dispute, a nasty back and forth with your ex, or a 2 a.m. text war. You snap, you scream, or you text something you don't really mean. Now you think you were just venting. You think the context matters. But when the police show up, those worst 5 seconds of your life aren't just venting anymore. They're now become evidence in a felony investigation. My name is William Pernik. I'm a state bar certified specialist in criminal law and a practicing California attorney. Today, we're going to break down Penal Code Section 422, criminal or terrorist threats. In the next several minutes, I'm going to walk you through the legal requirements for this charge, and I'm going to share with you some really helpful tips for how you can stop a moment of frustration from becoming a strike or a conviction on your permanent criminal record. Now, after 20 years in the courtroom, I've seen the same story 1,000 times. The system gets hypnotized by a scary sounding transcript. They focus on the threat in a vacuum, ignoring the context in which the words were said, and ignoring fully the person behind them with his or her own history and struggles. This charge is deeply personal to me for 2 reasons. First, because we're dealing with criminalizing words, I truly believe that the power of the state to punish speech must be used carefully. Unless we're dealing with true threats where someone is really intending to put a person in fear and the person is scared for their life, we should not allow the government to criminalize the speech it doesn't agree with. And second, I really hate how broadly this law is applied, because it often hurts people who are already struggling the most. Persons dealing with emotional difficulties, substance abuse, or trauma. Those who lose control in a mental health crisis and say things that now threaten to destroy a life that was already hard enough. Penal Code Section 422 is one of the most dangerous and overused charges in California, in part because it is a wobbler. The government has complete discretion to charge this crime as a felony or a misdemeanor. But if filed as a felony, it's not just a felony, it's also a strike. That means you could be facing prison time, doubled sentences in the future, and a permanent label as a serious felony offender. If you have 2 or more strikes on your record and you pick up another violation of Section 422, you could even be looking at life in prison. The real battle in these cases is often between being informed and being processed. You know you're being processed if your DA looks at a text or a police report and checks off a box, and then you go to jail. But if you are being informed, you can actually use the law to force the system to see the whole picture and hold the government to an actual legal standard. To turn your words into a crime, the government must prove 5 specific elements under Cal Crim 1300. The government has to show, beyond a reasonable doubt, that you willfully threaten to unlawfully kill or cause great bodily injury to someone else. They have to prove that you intended the statement to be taken as a threat and weren't just venting. The threat has to be so unequivocal, unconditional, immediate, and specific as to convey a gravity of purpose and a prospect of immediate execution. Your threat must actually cause the victim to be in a sustained fear, and that fear, it has to be reasonable under the totality of the circumstances. If even one of these links is broken, the law requires a not guilty verdict. We usually win these cases by proving the legal definition of a true criminal threat was never met. Defense number 1, lack of specific intent. If you were angry, pissed off, shouting at a wall, or using obvious hyperbole with no actual intent for the victim to feel threatened, you're not guilty of this crime. Defense number 2, voluntary intoxication. If you were so intoxicated that you couldn't form the specific intent to commit this crime, that too can be a complete defense. Defense number 3, lack of immediacy. The law requires an immediate prospect of execution. So if you're pissed off and you're yelling at someone you don't like while driving away, or if you had no way to actually act on the words you spoke, the crime is not complete. Defense number 4, conditionality. A threat that depends on a future, uncertain event. If you ever do X, I'll do Y, will often lack the gravity of purpose that the law requires, and that could be a defense. Defense number 5, vagueness. Statements like, "I'm going to get you" are ambiguous, they're vague, and a threat must be specific. If all it is just a bunch of trash talk, that's not a criminal threat under Section 422. Defense number 6, lack of sustained fear. If the alleged victim argues back or waits days to call the police, clearly the fear wasn't sustained. It was transitory, and that gives you a powerful defense. We anchor these defenses in the landmark case of In Re Ricky T. That's a juvenile case where a student told the teacher, "I'm gonna kick your ass," and the Court of Appeal actually overturned the conviction because the prosecution ignored the context within which the threat was made. Specifically, the Court of Appeals ruled that one cannot judge a threat solely based on the words. In that case, there was no prior history of violence, no physical show of force, no fists, no weapons, no pushing. In addition, because the police weren't notified until the next day, the court found the fear didn't exist beyond the moment of the encounter. Section 422 was not enacted to punish intemperate, rude, or insolent remarks. Without circumstances to corroborate a true threat, there is simply no crime. Now, if you or your loved one are facing a PC 422 investigation or prosecution, here's your roadmap. First, the don'ts. Please don't talk to the police. They will use your explanation of context to fill the gaps in their own case regarding your intent. Please don't reach out to the victim. In the best case scenario, your apology will be used as a confession or admission, and, even worse, it could make the victim even more upset or afraid. And the government could try to charge you with additional crime of intimidating or dissuading a witness. Please do not delete messages. Deleting evidence looks like conscience of guilt. It could also hurt your lawyer's ability to understand the full context of what happened. The do's. Do preserve the full conversation. The context of the other person's behavior is vital. It could help us understand why you were provoked, why you said what you said, how you were being egged on. Do seek a clinical evaluation immediately if this was driven by a crisis. We need to document what happened to you and get you into treatment in order to qualify you for potential powerful alternatives like mental health diversion, veteran diversion, or many other creative programs that exist under California law. If you have knowledge of post-threat behavior by the victim, please document it and share it with your lawyer. In many cases, that could help prove that the person was not in sustained fear. In conclusion, I want you to know the system is built to process you based on your worst 5 seconds. But I'm here to provide the attention that's often missing, to look at the person behind the words and the constitutional rights and legal standards that protect them. Just because you said something that was rude, angry, or just plain wrong does not make you a criminal. You may have powerful factual defenses and legal alternatives under California law. To learn more, please visit us at perniklaw.com. Hit like and subscribe to our videos. Thank you for watching.